might feel like it's burning, or instances where it could cause a hypothermia because the water was so cold. And this is another instance where secondary risk is something that we need to keep in mind. The risk with water cannons is when the fourth will throw someone against a wall or the ground, leading to serious injury. Next. There we go. And then I could not continue this presentation without mentioning drones, which Mike has always pushed us a lot to consider. And it is true, the difficulty here as well is how many new weapons, or kind of how hard it is to keep up with different technologies. There are documentations of the use of drones to deploy crowd control weapons in Palestine. We think that's the only place that it has been used, but we know that this is a technology that's been purchased by several dozen other countries. Millimeter wave weapons, which really sounds like something out of a sci-fi novel. Electrified projectiles. And then here's an example of Ebola wrap. So it's a projection, kind of a line, and then would wrap around someone. And this is something that is kind of proudly shown and exhibited in crowd control weapons fairs around the world. So final reflections here, and I hope you have questions afterwards. I'd be happy to kind of go more. But even if crowd control weapons were developed as an alternative to lethal force, that is not necessarily a simple dichotomy. They are extremely dangerous. Some of them, especially depending on how they are used, how they're employed, if police officers have been trained correctly, and they should be only used as a last resort, right? Some of them are inherently inaccurate, indiscriminate, and or cruel, and should never be used in crowd control settings. So once again, Lethal in Disguise 2 would say rubber bullets, multiple projectiles should never ever be used. And things to kind of keep in mind: hybrid weapons, the secondary risks that I mentioned, and these misuse of otherwise permitted weapons. Some positives, because it's important to end there. I think there's an increased recognition about the severe injuries and long-term impacts, even mental health impacts, which we don't talk about a lot. And there's some advances on guidances in trade, which I'm hoping presentations afterwards will cover, and some small cases of the withdrawal of weapons due to kind of public pressure. So I'll end with, this is a global issue, and therefore I think we need some sort of global solution or global partnerships to be able to counter it. So thank you.
Thank you very much, and thanks to everyone who's taken the time to come out in the cold. It's the last cold front of the season, hopefully, and we can move on. Given the joys and the challenges of COVID, I've been working with Lau and Cheryl for at least 4 years, if not longer. And this is the first week we've actually met in person. So it's a pleasure to be here. Thank you. It's also just important to recognize Maury Hawthorne, who joins today. For those not in the know, Maury is an iconic human rights lawyer, and at least my generation of lawyers looks up to Maury for a lot of the work that he's done. So Maury, it's a pleasure to have you in the room. For my presentation today, I want to really just tell 2 stories. The first story is about a South African academic, a Swiss diplomat, and an international network of civil liberties organizations. And the second story is unfortunately a bit more tragic, and that is about a recalcitrant state security apparatus. I'm going to start with the latter, and we'll move on to the former, and I look forward to the conversation during the course of today. So if we can move to the first slide, and just by way of setting context, we can move one forward. I just want us to remember where we come from, right? So if we look at 3 provisions from the South African preamble, there is an obligation on all of us, inclusive of the state, to ensure that we heal the divisions of the past and establish a society based on social justice and fundamental human rights. There's an obligation on the state to ensure and free the potential of each person. And there is a recognition in our preamble that we are part of the family of nations and therefore bind ourselves to international law. This is affirmed in the preamble in our 1996 Constitution. But sadly, when we look within the protest context and more broadly misuses or abuse of force by the police, we go forward in time to the next slide, which is 2016, and its concluding observations from the UN Human Rights Committee. Now, the UN Human Rights Committee is a body of experts responsible for monitoring the International Covenant on Civil and Political Rights. They're an authoritative body that gives guidance on either state compliance or state violation with these fundamental international law principles. And here, in 2016, 20 years after our Constitution, the Human Rights Committee notes with concern numerous reports of excessive and disproportionate use of force by law enforcement officials in the context of public protests that has resulted in the loss of lives. This is 2016. In 2011, Andries Tatane is shot from close range with rubber balls and killed in Vicksburg. In 2012, the Marikana massacre happens. And 4 years after that, an authoritative international body is condemning the South African security apparatus, which includes the police, for the loss of life and for non-compliance with international law. If we move forward 3 years later, we now get to the Committee Against Torture. And here they again call upon the South African government to revise laws and policies regarding public order policing and the use of force, including lethal force, by law enforcement officials in order to ensure that all policing laws, policies, and guidelines are consistent with the basic principles on the use of force and firearms by law enforcement officials. And to the last part of the story, we then move to a decision of Justice Fabricius. Mr. Collins Causa, as many of you will recall, was killed early in the COVID pandemic over the 2020 Easter weekend. He was sitting in his yard in Alex, and members of the South African National Defense Force. He died through blunt force trauma, and he was hit with the butt of an R5 rifle and effectively murdered during a time where we looked to the state for leadership, not for assault. And here you can read the pain in Justice Fabricius's judgment, reminding us of the basic human rights that all South Africans are entitled to. The public is entitled to be treated with dignity and respect, whether rich or poor. Section 7 of the Bill of Rights makes this abundantly clear, and there is no doubt about that. The public is also entitled to human dignity, and this right needs to be respected and protected, as again made abundantly clear by Section 10. He then deals with Section 11 and Section 12 and reminds the security apparatus that the right to be free from all forms of violence is bestowed on each person in South Africa, and it's from both public and private sources. So this is the story about a recalcitrant state apparatus, right? Who 24 years in this instance, after we confirm the preamble in our Constitution, is still wildly incapable of respecting fundamental rights, 1, and 2, creating an enabling environment where people can flourish, where South Africans can grow. We're going to get back to the South African legal provisions, but that really just paints the context of where we are in terms of recalcitrance, a slow regulatory reform pace, and the status of the South African Police Service. But let's turn to the first story. And for those who have worked in these spaces, you will know of Christoph Heyns. He was an academic at the University of Pretoria. He has sadly passed away. But he is the South African academic in the story. And to tee up Thomas will be speaking shortly, but Thomas worked very closely with Christoph. The second person in this story is a Swiss diplomat who got behind the right to protest movement in the mid-2010s and in many ways enabled protest reform at the international level. The third is INCLO, the International Network of Civil Liberties Organizations. So in 2015, INCLO publishes Lethal in Disguise 1. And it's relatively novel research, and it's the first time that crowd control weapons are properly foregrounded as a legal question. Late in 2015, Christoph Haynes, who's then the Special Rapporteur on the Right to Life at the United Nations, starts working with the Special Rapporteur on Freedom of Expression, Marikana, a Kenyan lawyer, and they publish a report which starts introducing this idea of the challenges around crowd control weapons into international discussion. At this stage, Thomas is working with Christoph, but Christoph, alongside Marikana, and enabled by some of the research by INCLO, really start grappling with this idea. Shoot to 2017, and the African Commission, through advocacy efforts by people like Christoph and others, is starting to consider how we regulate crowd control weapons in international law. And in 2017, the guidelines, you'll see them, it'll be on the next slide, but we can keep the slide for now. In 2017, guidelines are passed by the African Commission, which effectively foregrounds a lot of the thinking that will go into subsequent United Nations work. At this meeting, it's chaired by Panzi Tlakula, who is now our information regulator, but was then the chairperson of the African Commission. Of course, Christoph is there, and members of INCLO are there to try influence and strengthen these guidelines. We then move forward, and you can see on the right-hand side of the screen, one slide back, please. We then have a series of general comments. So just for clarity, a general comment is effectively a statement on an individual right in the International Covenant on Civil and Political Rights. Right? So we have 3 founding documents in international law: the Universal Declaration on Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. Those together are referred colloquially as the International Bill of Rights, but this foregrounds and really underpins the entire international law system. A general comment is a statement that explains and expresses and develops one of those individual rights. Christoph has now left his special rapporteurship and is now a member of the UN Human Rights Committee. And under Christoph's leadership, in 2018, the UN publishes General Comment 36 on the right to life and really starts grappling with less harmful means of engagement, this direct crowd control weapons question. This is after the work that's done in 2017 on the African guidelines. In 2020, General Comment 37 is passed. And here, General Comment 37 looks expressly at the right to protest and deals substantively with a lot of the questions around crowd control weapons. It borrows from the African guidelines, and you can see this progression of international law, which is largely led by the South African academic Christoph, but which is enabled through the Swiss diplomat who is passing resolutions at the Human Rights Committee, keeping the right to protest on the agenda of the United Nations. And then most importantly, the UN guidance on less lethal weapons is published in 2010 by the Geneva Academy on International Law, supported by the Swiss mission and the Swiss diplomat who are enabling this process. Now that document is authoritative in that it covers the primary principles around the use of force. Use of force needs to be necessary, right? I think for those who came to Constitution Hill today, you'll see that there's an ongoing sit-in protest that has been on this hill for over 2 years now, where a group of older persons are protesting for the right of reparations following apartheid. They've been given a space to continue their sit-in. But the question to you now is, would it be necessary to simply just start throwing tear gas canisters at this group of protesting people? It would be disproportionate. They're not proposing a threat to Constitution Hill at this stage, and this all requires sensitivity and situational awareness, the policing term in managing protest. But the guidance deals with all of these questions. It deals with legality, precaution, necessity, proportionality, non-discrimination, and most importantly, accountability of police officers who violate laws. It also gives very specific guidance on how to use certain crowd control weapons. You know, I was at Marikana, I was at the LRC at that time, and we were representing a family there. And through disclosures at the commission, we came across a training manual that the South African Police Service used. And they were trained to shoot rubber balls, not into people, but into the ground before people, so they bounced into people, right? But you lose the targeted authority. If you're not on a perfectly tarred road, you start shooting weapons into the ground, they ricochet, and they start hitting unintended targets. And it goes to the discriminate question that Laura was talking about earlier. It's the same as tear gas. Tear gas blows in the wind. And while you may throw it at a group of protesters, it can blow into someone's yard. It's the same with water cannon as well. So the human rights guidance deals very deep, gives very specific guidance on each weapon, and it also deals with what Cheryl referred to as looking at protest in 3 phases. Before the protest, what happens? The police need to prepare. They need to understand where protesters may go. During the protest, how you manage the protest action, and then after the protest, medical assistance if people have been harmed, accountability, judicial action. So it gives complete and comprehensive guidance, and it really expands what are the 2 fundamental international law documents on the use of force, which is the Code of Conduct for Law Enforcement Officials from 1979 and the Basic Principles. Now you'll recall from the Committee Against Torture's recommendations in 2019, they're still asking South Africa to comply with 1990 international law, which we are yet to do. So what we see here is a beautiful story of activism. INCLO was in all of these meetings trying to develop the international law position on less lethal weapons. In many ways, that is topped out. International law as it pertains to less lethal weapons is wonderfully considered and nuanced, and those spaces for advocacy, subject to some other nuances that need to occur, have rarely been covered. But a South African academic, a Swiss diplomat, and an international network of human rights actors and activists are responsible for what is a fundamental shift in international law from 2015 to 2020. And there's a lot to take from that in terms of learning. International law can be developed and it can be trained. It can be changed. Passing treaties is a slightly different thing, but this is a wonderful progression, and I think a lot can be said about the work of the LRC, INCLO, and others in setting the international law agenda. The story then turns for the worse again. Can we change the slide? I'm going to skip over the regional law. It's not relevant for present purposes. But now we get to the South African perspective, right? So 1979 Criminal Procedure Act, you would have heard about shoot to kill. It's been in popular parlance for a lot of our policing ministers. That really comes from Section 49.2 of the Criminal Procedure Act, and that authorizes the police to use lawful force in certain circumstances in effecting arrest. It has been amended to mitigate how much force the police can use, but the South African Police Service, as we all know, holds a monopoly on the use of force in South Africa. Any policing service in a democracy has monopolized the use of force. And Section 49.2 is effectively that enabling provision. We then have the 1993 Regulations of Gatherings Act, which is a pre-constitutional piece of legislation, but which still governs the right to protest today. In Joburg, you have to drive out to Marshalltown, you have to meet with a convener on a Wednesday morning, you have to really only give notice in terms of the law, but in practice you're seeking permission from the state to protest. It hasn't been reformed since 1993. In 2018, the Freedom Front Plus put in a private members bill to try to restrict it further, but that bill, thankfully, has not been taken further. We then have Section 205.3 of the Constitution, which really empowers the police to engage in public order policing and manage public disorder, right? And there's a fundamental tension that exists in international fora, in conversations with the police, in that activists, human rights lawyers, and the public look at the question of law and order as law first and order second, right? Police often approach that question the other way around. Their primary requirement is to ensure order, and on occasion, like we saw in Marikana, the law is sidestepped. We have the Correctional Services Act, which deals with how prisoners are detained. And we see, which I think Thomas may speak about a bit later, but in correctional facilities, less lethal weapons are often misused. You know, horror stories have come out of the INCLO network where prisoners are thrown into the shower and then electrocuted with shock shields. as a form of punishment. And these misuses are often highly overutilized in prison facilities because there's less public sight. The press, others can't see the misuse of these weapons. We then have the IPID Act, and as everyone knows, the independent police are meant to oversee the South African Police Service, but for all intents and purposes, I wouldn't pass them on their efficacy over the last 20 years. They simply haven't done a good job. They're under-researched, under-resourced, and a lot of questions need to be asked about the work of IPID. So we have Andries Tatani killed in 2011. We have Marikana, which occurs in 2012. And then we have the two fundamental documents which govern how police engage in protest settings. Standing Order 262, which was amended after Marikana gently, which is now National Instruction 4 of 2014. And National Instruction 4 is a very complex document. It's about 20 pages, and it details exactly what the police must do, when they can discharge weapons, how they must give notice before they're going to disperse a protest. And while it's a useful document on paper, it is not often properly complied with by the South African Police Service. And then I think most importantly in closing out this section, acknowledging that international law is strong, acknowledging the role of Christoph and others. After Marikana, a panel is established to investigate police reform. In 2021, Christoph, through his center at the University of Pretoria, in consultation with this panel, introduces a model law based on all of the wonderful gains that we've seen in the international system, reminded that in our preamble we commit to binding ourselves to international law, and introduces this model bill which really consolidates all of South Africa's legislation into an internationally harmonized bill on the use of force in South Africa. That was the last proactive step that was taken in this space. That bill, at this stage, as far as I understand it, has gone absolutely nowhere. So we see a beautiful story of advocacy at the international level, and we see challenges with implementing policy and necessary legal reform, even in the face of a post-democratic massacre. There isn't sufficient action coming through our legislative and policy bodies. So then on to the last slide, and this is where I would welcome conversations to start, but everyone asks, so what do we do, right? And there's a lot of work we can do. I think civil society needs to continue to go to international spaces, to continue to go to the Human Rights Committee, to the Committee Against Torture, and keep reminding the South African government that we are not complying with our international obligations. We need to keep that pressure up. We need to continue to advocate for domestic reforms and proactive disclosure. The problem we have with the police is we never really see their documentation, right? And as we know, our Promotion of Access to Information Act is in many ways insufficient. We always have to go through these bureaucratic and burdensome processes to get information which is actually public information. So instead of us always having to ask, proactive disclosure should start to take place. I think we need to enable partnerships and training. The police are undertrained. And I appreciate, in my time at the LRC, we took a position that we wouldn't engage in training of the police because we needed to litigate against them. That may be so, but other organizations may want to fulfill that role. A big problem which we're starting to notice, and for those at the LRC, Steve Karnowitz was really concerned about it sort of in the mid-2010s, but is declaring localized or national states of emergency and allowing for military deployments alongside policing. We saw it in a localized case at Marikana. We then saw it during COVID, which led to the death of Mr. Khoza, and we're now starting to see it increasingly. You know, not a month goes by where we don't get a news notification that the South African taxpayer is spending millions on yet another military deployment. And if the military is going to be using force, if they are going to be used to protest police or to police protests, we really need to understand what training the military is receiving, and we really need to be cautious about our president, who seems very comfortable to deploy the military against South African citizens increasingly. So there's a deep reflection that needs to take place there. The military does play its role, and it can support in times of crisis, like the floods in KZN. But it may be that we're simply deploying the military too quickly, at this stage. Another useful capability, and I know the LRC and INCLO have been engaging in trainings this week, but is to have protest monitoring organizations. In Brazil, there's a wonderful protest culture. And not just those who are taking to the streets, but those who are enabling those who are taking to the streets. So there they have people who deploy to simply record the protest monitors, who are not per se part of the protest, but they gather evidence so that you can litigate if there are misuses of power. And they also deploy medics. I mean, often when violence occurs, our medical services come too late, right? And they deploy private medics in protest situations, knowing invariably that force will be used and that lives need to be saved. And then the last thing is, hopefully if we can get our evidence collection systems more effective, we need to litigate more. It's time where we need to start compelling compliance with international obligations and seeking domestic reform. And I think just very anecdotally, before I was leaving the LLC, we were doing a lot of protest litigation. And this was when we didn't get permission from the police in Marshalltown, and we had to take it to court. And we did a couple of things. In terms of the Regulation of Gatherings Act, your first port of call is magistrates' courts. But what we started doing is seeking to challenge provisions. These were urgent applications, but we would just put in a constitutional challenge to the RGA in our applications so we could bump jurisdiction into the High Court. We could get a quicker audience with a High Court judge, but what then invariably happened is we settled and the protest went ahead the next day. What we weren't very effective at doing is supporting both the protesters and getting in institutional applicants. So regardless of whether or not the protest took place, we could still continue with that constitutional challenge against the RGA and other relevant legislation. So there's really space for all of us to fulfill a role here, whether you're engaged in international advocacy, whether you're engaged in training or research, or whether you're an impact litigator. I think we need to reimagine the collaboration that we have between the various organizations and actors in the space. And given the unfortunate story of the recalcitrant security apparatus, it strikes me that it's time for action. So with that, Chair, thank you, and I'll hand back to you.
Thanks so much, Michael and Laura. I think that was brilliant, and I think I already have a lot of questions. But I want to hand over to Thomas. Thomas, are you with us?
So, can you hear me?
We can hear you, but we can't see you.
Okay. Are you still seeing Michael's slides, maybe?
Yeah. Just...
do you see me now?
Not yet.
Does that help?
Yep. There we go. Welcome,
okay.
Thomas.
Okay.
Yes, over to you.
Thank you very much, Cheryl, and it's great to have been able to listen to both Laura and Michael and those very detailed presentations, and just to I suppose foot stomp the second anecdote that Michael was referring to about the synergy between civil society advocacy and the network effects of organizations specifically like INCLO that bring together civil society from so many different corners of the world, leveraging that expertise, that lived experience, and that passion, and putting it in those otherwise sometimes quite dry international rooms in Geneva that Christophe and I had the pleasure of and the honor of being in for so many of these conversations, bringing that experience that INCLO was able to do into those rooms, I think materially improved so many of those conversations, and I hope so many of the documents that came out of them. And it's a process that I think is continuing. I last saw Michael in the discussions around the less lethal weapons guidance back in 2019, but Laura and I were together in Geneva. and the development of a model protocol for how the police and other institutional actors respond specifically to assembly. But to zoom out slightly from the assembly context and to speak about less lethal weapons and the regulation of less lethal weapons in general, and to pick up the story where Michael left off, I suppose, with respect to the less lethal weapons guidance. There you have, I think, broadly kind of three spheres in which international law can try to address the kinds of harms and threats that emerge from these technologies, and that Laura and the report detail so marvelously. The first is in their immediate use. You know, how Can you hear me?
Yeah, you're back on now.
Great. So the first is the immediate use of the weapon, and as Michael said, the less lethal weapons guidance picks on some general categories of these weapons and provides indication of both how they should be used and perhaps more helpfully from an advocacy perspective, some kind of categorical descriptions of how they should not be used. But then all of this really stems from that core obligation with respect to the use of force by law enforcement officials, established actually less explicitly in the basic principles, but certainly in the 25 years since their adoption, this obligation of precaution, the idea that the state should be taking measures before the use of force to minimize the risk of their use of force, and the less lethal weapons guidance goes some way in doing that in this second category of kind of obligations around less lethal weapons, which is the ways in which police departments end up getting the weapons, right? Processes of procurement, needs assessment, deciding what kind of equipment is appropriate for the policing context that particular department is working in, testing, training around the use of this equipment, and the less lethal weapons guidance goes some way in sketching out what all of those, at least what good practice would look like in that context, and re-articulating the underlying obligation of precaution that requires that process. But although it does quite briefly discuss transfer of weapons, what the less lethal weapons guidance is less able to do as a soft law instrument is to discuss then the third broad category of area where international law can engage, which is around the trade in this equipment, both in terms of kind of bilateral transfer, and that's where the guidance did say something where as part of bilateral security assistance, especially in a development context, states sometimes provide law enforcement equipment to beneficiary states, and there the guidance was able to say something about the kinds of human rights impact assessment that donor states should be doing. But beyond that, there is a massive, it was recently estimated, I think in 2023, to be a $12.5 billion market in the trade of less lethal law enforcement equipment, which was up from $7.5 billion in 2020. So the trend of this marketplace in law enforcement equipment is massive and growing, and so I think kind of building upon exactly that same kind of advocacy space and international discussion around this issue set that has been bubbling along, as Michael was describing, since the mid-2010s. The latest kind of front in the campaign is definitely this marketplace, this trade, and the processes have been ongoing pretty much immediately following the finalization of the human rights guidance. A vote was taken in the General Assembly to appoint a group of governmental experts to reflect upon this trade, which that group produced a report which was delivered to the General Assembly in 2022, and that recommended kind of steps being taken towards a treaty that would regulate this trade. The Special Rapporteur on Torture has joined the kind of group of special procedure mandate holders very much engaged with this topic, and the new Special Rapporteur on Torture, Dr. Edwards, delivered a report to the General Assembly last year that detailed kind of went even further than the less lethal weapons guidance in the granularity of the detail with respect to different weapons, and very much continuing this other dichotomy in the trade between a group of weapons that have no legitimate law enforcement function, and Laura's presentation showed you a few of them. Spiked batons are perhaps the most intuitive example of that, but also direct contact electrical shock weapons, and a host of others that are being produced by hundreds of companies around the world, nearly half of them in Asia, a significant proportion in North America, and most of the rest in Europe, that are producing at least one of the weapons that is on this kind of first list of equipment that should just be banned. There is no legitimate reason to be trading in this kind of equipment, and their existing international law obligations under the Convention Against Torture, and in the African context, even more explicitly under the Robben Island Guidelines, make clear that states have an obligation not to be trading in equipment designed for the infliction of torture. The more difficult category, and the one that does, it seems, require some new international law, is the trade in equipment that can have a legitimate law enforcement purpose, like tear gas, though some international human rights experts disagree about the legitimacy of tear gas in most circumstances, but I think it's in the category of weapon that in a very limited number of circumstances can have a legitimate use, and some of those kinetic impact projectiles that Laura showed can be used in a safe way. And so how states should, how companies should be regulated by states and by international treaties between states to facilitate a trade in that equipment that better protects the fundamental rights that Michael was adverting to, and that is the process that INCLO and a host of other NGOs around the world are currently engaged in, an alliance among states of 60 or 70 states who have joined together into an alliance for a torture-free trade, and then a growing network of nearly 100 NGOs who are currently campaigning for a resolution, basically in New York, to begin the process of negotiating the text of a treaty that would look something like the Arms Trade Treaty. The Arms Trade Treaty, of course, not a universally ratified treaty, but quite a good legal instrument for the regulation of a particular kind of weapon. It doesn't include most of the some of the kinetic impact projectiles probably are covered under the Arms Trade Treaty, but a lot of the equipment that you've been discussing this morning is not and cannot be regulated under the Arms Trade Treaty. And so the development of a new international treaty that would impose similar kinds of import-export regulations on this very dangerous form of equipment is what we're all campaigning for. South Africa, unfortunately, as Michael was adverting to its failure to comply with some of its international legal obligations with respect to the use of force. Unfortunately, it hasn't taken an especially progressive position yet on this question. It hasn't taken a negative position. It just hasn't really pronounced itself yet. And so trying to advocate for South Africa to become a little bit more of a leader in this space in New York is I imagine part of the purpose of this gathering, and it's a great pleasure to join you. I won't say any more than that because I suspect we want to leave as much time as possible for the discussion. So Cheryl, I'll pass the floor back to you.
Thank you so much, Thomas. And maybe I will stay on you for the first question because that's essentially, I think you've said that South Africa hasn't taken a position. What do you think, in your opinion, should we be doing to put pressure on the South African government to join this process?
I mean, I think that the process that lies behind a government moving from an undecided or uncommitted state in New York into joining the Alliance for Torture-Free Trade, or ultimately when the resolution comes to the floor, which almost certainly won't take place in the coming session of the General Assembly. So it's the session after that. It'll be kind of the autumn, the New York autumn of 2025. But the process of shifting a government's position in that respect is an intra-ministerial one. The Department of Foreign Affairs will ultimately defer, I think, to the Ministry of Justice, and they may defer to SAPS as well. So I think the liaison between some of those different departments and sensitizing them to what the implications of such a treaty would be. South Africa is not a state with as it were, a record to be ashamed of in this space. I mean, there are South African manufacturers of crowd control weapons, but I don't believe that any of them are trading in the type of equipment in that first schedule of completely illegitimate goods. There is a significant South African export of goods that would become regulated under such a treaty, but the steps to persuade the South African government that actually complying with such a treaty would not be more onerous than the kinds of compliance that they already undertake with respect to the Arms Trade Treaty, a treaty that they are an advocate of. You know, they were a relatively early party to the Arms Trade Treaty, and have subsequently, in presentations that they would make to meetings of state parties of the Arms Trade Treaty, speak kind of passionately, or as passionately as one can in international treaty settings, of the merits of that form of regulation and the collaboration, monitoring, and accountability that a treaty brings. And so highlighting to them that just as they have a trade in arms trade treaty related equipment, they have a trade in this other kind of equipment, and the same logics of bringing up the floor of practice, monitoring, and accountability hold for this equipment too. So I think those kind of conversations with the relevant ministries, Justice, Foreign Affairs, that they are our advocacy targets, as it were.
Yes. Maybe Michael, Laura, do you want to answer that question? Do you have any further input?
I think the only thing I would add is the importance of it to be truly a global sort of push forward. I think it's easy to, or not, it's not easy, but once one starts to think about the complexity of this market, where you can have a technology that is developed in one country, traded in another, and then used in another with very little transparency, it shows that truly, even if there are the best practices in one particular country, it doesn't solve sort of that global issue. And once again, I think the potential impact of having South Africa take a more sort of proactive role just regionally would be huge. I think there's this, we're very much pushing and looking for champions regionally. And so even though maybe South Africa, most of its production is for domestic use, there are sort of weapons that come through South Africa and then are distributed elsewhere, or either way. So I think that the work for regional champions, for it to be effective and move forward in our advocacy is a key goal for, or should be a key goal for all of us.
Thank you. I mean, for me, you know, we've got a new chief diplomat. Mr. Lamola has moved from justice to DIRCO. He now leads our efforts in diplomacy. And I mean, South Africa has been very proactive on certain questions in the international fora recently. And I think the role of the LRC and INCLO and others is to package the opportunities available to South Africa, and particularly the individual diplomats who will drive this agenda, and go have a conversation. Put it on the agenda. You know, the GNU is still very much in a testing phase. We're seeing where this all goes. But we do have a young, ambitious chief diplomat who is looking for things to do at the international level. And I think start the conversation, but prepare a package that shows him a pathway and a reason for South Africa's championing of the process. And it may well be that if the message is clear, he may take the initiative on. But I think it all starts with formulating a new relationship and observing where DIRCO now goes under his leadership.
So I want to talk a little about the report now. Laura, one of the things that, you know, we've had 2 workshops, training workshops with grassroots movement. So some of this might not come across, you know, without the background knowledge. But one of the things that we spoke about were KIPs, you know, and in the report calls for a total ban on you know, rubber bullets, and but you know, the UN guidelines don't hold the same view. So why the divergence from these best practices? Is there a place for, you know, KIPs in protest at all? According to INCLO, you say no. But the UN guidelines have left that open. What are your thoughts around that, and why? What was the thinking around? How did you come to that conclusion that this is INCLO's position, that we want a total prohibition on KIPs? And the same with tear gas. Thomas mentioned this now about whether that's a legitimate crowd control weapon. But I think INCLO also has the same reservations around the use of tear gas. You know, you said that it was used in war, and it's been prohibited in the use of war, but it's now commonplace in protest action. So let me hear your thoughts about that. And then, obviously, Michael and Thomas, if you also have some input, you can also follow Laura.
So I mean, in the first place, I think we see the UN tools and standards as kind of our minimum, where we start to kind of work through. But I think the recommendations and why we've come to that different conclusion has to do with this partnership that INCLO has done with Physicians for Human Rights. So the uniqueness of it is that it is based on medical literature, and so based on medical reviewed peer reports or papers. What that does mean, and so I'll speak to a weakness perhaps of the report, is that what we have in terms of data is the tip of the iceberg, right? But we wanted to do that so that it was, data that was almost undisputable, even though we know that when we're talking about numbers of deaths or injuries, it is just a small proportion of that. And within that medical review, and I wish, Rohini Har is kind of the physician, emergency doctor that also co-authored the report. We were lucky to have her join remotely in the workshops. But so all of this is based on the medical impacts of it. And so looking at what that does in practice, and especially when there isn't the correct training, which is, more often than not, when there is a militarized culture of policing, when there are many things that we need to be working within of kind of how protesters are seen and what the role of policing has kind of become. And so within that, what we've seen is that these are inherently dangerous. With KIPs, they will function as a firearm or as a lethal weapon if it is at short distance, which we've seen many times. And then there is kind of that inherent, and so that was a little bit where the reasoning for both KIPs and for tear gas, for the recommendation for them not to be used, is that they are indiscriminate in nature. And therefore, there is no, even when all of the right precautions are used, or when it's used perfectly by a perfectly trained law enforcement officer, the chances of an individual being hit in vulnerable places, the risk of someone around them, at protesters being affected, or bystanders are enormous. And therefore, we think that is not something that should be included in crowd management.
Thank you, Laura. I mean, I think there's two responses, right? So in the South African context on KIPs, we obviously have evidence of a range of misuses resulting in death. We don't accurately know, publicly know, how public order policing officers are trained on the use or deployment of rubber balls. And for me, it's a bit of a conversation that needs to take place in public. If the police are prepared to share how people are trained, and to give public confidence that there will not be misuses of this weapon, I think it would go a long way to fostering public trust in the policing capabilities of SAPS. But they continue to act behind a veil of silence, and we continue to read news reports about deaths resulting from the use of these particular weapons. So there's a conversation that needs to take place there. I think when it comes to the broader question about the recommendations made by INCLO, you also got to look at the actors in these international spaces. And civil society, if we go back to sort of, at least in the South African context and the original preamble provisions that I showed at the beginning of our presentation, civil society needs to hold the line in ensuring social justice and the protection and promotion of fundamental rights. Civil society also has to play a role in ensuring that people can reach their potential, right? So when civil society's voice is heard, it needs to set standards, and this is what this report does. Now, when we go into international spaces, you'll have civil society wanting the higher standard. The police will come in with a very low standard. And the writers of these laws will come in and try find that measure. But civil society needs to act as that counterbalance and needs to be in those rooms. Otherwise, the standards are watered down and they're reduced. There is credible medical evidence that these weapons are largely indiscriminate, and there's even more social evidence that they're misused. And I think that's the position that INCLO is coming from. Now, it doesn't answer the question effectively as to how you should properly police protest and what weapons are permissible. But that's for the experts to tell us on. We as the social justice sort of group at the negotiating table are there to set that standard. And I think the report accurately does that, to continue the international conversation and to show the treaty writers and the police services what may be possible, and then for them to persuade us why it's not the other way around.
Thomas, do you have anything to add?
Well, maybe to try and explain slightly the difference. Well, to make two observations. Firstly, that a lot of the kits that one sees used and that the report documents the use of are kits that the international guidance would view as potentially unlawful. So a lot of them are either multiple projectiles within the same canister, or being used in a kind of automatic fire or multiple launcher, all of which would not be permissible under the international guidance if one views it as a kind of binding instrument. And then the other thing to note is that the context of use of the guidance is with respect to less lethal weapons in all contexts. It's not, whereas the report has the narrower focus on in a crowd control setting, and there can be weapons that would be legitimate weapons potentially for use in another context, but may not be the most sensible weapon to use in a crowd control setting, where you've got the likelihood of a bystander being injured if you slightly miss your target is perhaps higher in a crowd control setting than in other settings. Though that second caveat wouldn't necessarily be to say that I think the international guidance suggests that they are an ill-advised weapon in a crowd control setting. If one were using, as it were, the legitimate version of this weapon, I think it would probably be and this, I suppose, is Michael's point, that with clearer, firstly, clarity about the fact that you're using the right version of the weapon, and then clarity around how law enforcement officials are being trained to use it, including, if they are, getting specific guidance about the risks and context in which it might be legitimate to use in a crowd control setting, then that would, I think, significantly move the ball forward. And at all times, the context here is that the alternative to the equipment of the police being these may be that they resort to the use of firearms. And I think that the context, at least in which Christoph and I came to this work, was always with the context that, well, we would prefer that they're using these than that they're using firearms, especially in a crowd control setting. But we need to get clearer regulation about how and what safeguards there are around their use if they're going to kind of move in this more precautionary direction of using a kit, for example. Right.
So in terms of regulation, Mike, if I can start with you, you've mentioned National Instruction 4, you've mentioned the RGA, the Regulations of Gathering Act. The high-level panel, the Marikana high-level panel, in their report said that both the RGA as well as National Instruction 4 is not rooted in the right to peaceful assembly. And they called for a review of both, the instruction as well as the RGA. I mean, do you agree that the RGA at the moment, the way that it is drafted, is not rooted in the right to peaceful assembly? And do you think that the RGA, specifically on the use of force, is sufficient enough? Because there are provisions there around when crowd control weapons are deployed, who it should be deployed by, and in what instances it should be deployed. So under very, very specific circumstances where there could be imminent danger to a person's life or damage to property. I know there have been a lot of debates about whether protection of property versus protection of life should have been covered under the RGA. But I'd like to get your thoughts on what exactly do we need in terms of domestic regulation in respect of crowd control weapons, and specifically in the context of protesting?
Thank you. It's a fair question, and it's one that's elicited a lot of debate, I suppose, in legal and protest circles. The RGA, I mean, the fundamental premise of the RGA is to enable a process where the state can be notified of protest action and reasonable accommodations, measures can be taken to manage and facilitate that process, right? It's the way, it's not to stop the protest, it's not to engage in crowd control, it's to facilitate the protest action. Shut off an intersection so the protesters can walk through. Open a door, whatever it may be. There's a different narrative that needs to take place. Now, the RGA itself is fine when it comes to protest notification provisions. Where the RGA is weak is on accountability. So, those three buckets we were talking about, sort of pre, during, and post. Pre, the RGA sets out a reasonable framework to engage in protest action. During, I mean, international law has developed somewhat, so the RGA lacks sufficient nuance to grapple with a lot of the more contemporary questions that are coming out of international law. So it covers the basics in the 1990s sort of UN documents. It doesn't cover more of the nuance. And then it's wholly deficient when it comes to after the fact, really where command responsibility is. For example, there are very practical questions that we see some of it in the national instruction, but it could be reduced to legislation to give the public more access to court should there be violations. But if a commander deploys young, untrained police officers who then overreact in a protest setting, who is to blame? We need to grapple with that in legislation. The Irish have a great example that those who are armed cannot be on the front line. Because on the front line, you're getting spat at, people throw things at you. You get quite angry just as a human being who is a police officer who perceived to be being abused by a protest crowd. So those who hold weapons cannot be on the front line because of that possibility of overreaction. So this deep question around command and control of public order policing needs to be better addressed, either through the RGA or through separate legislation where clear records need to be kept. Actual commands need to be recorded. We saw it at Marikana, right? Commands were going through all the water cannons. We all got to the commission and magically nothing was recording, right? All of the commands had just disappeared into thin air. So we couldn't hold specific people responsible through those general reporting. So the RGA meets the mark, but I think where we're going, and in a democratic dispensation, it lacks the requisite nuance to cater for what in the South African context is largely localized sort of community protest as opposed to national protest action. So it could do with a bit of a revamp. The political question, though, is whether now's the right time. We see the bill that was introduced by the Freedom Front Plus in 2018, which wanted to substantially weaken protest provisions under the RGA and give the state more power to manage protest. So the question we have for ourselves is to look at our current lawmakers and make a political decision as to whether this group is the right group to enact progressive laws. I'm not going to pass judgment on that just yet, but it's something for all of us to reflect on.
Thomas, do you have anything to add to that?
No, nothing specific other than maybe just to note that the Civilian Secretariat of the Police did slightly after the 2018 incident that Michael spoke about. There was an initiative in 2020, I think, to put together the Civilian Secretariat of the Police put forward proposed amendment legislation both to the SAPS Act and to the RGA. It was largely to the SAPS Act, but there were a couple of provisions that did relate to the RGA. I know that went to a public consultation, which we participated in, but haven't heard. I believe that the legislation then subsequently died in the political morass of the following few years. Whether there have been initiatives from the Civilian Secretariat or elsewhere to resurrect that, I don't know.
Yeah. So, I mean, just going back to you, Mike. As everybody, Thomas has said, you've said, I think Laura, you've also said that we've got pretty good guidance at the international level, and to a certain extent we have, some foundations on local level. What is the next step in your mind for standard setting? What improved tools or strategies do we need to improve accountability?
Yeah, thank you. I mean, in terms of standard setting, the international standards are there, and I think it's not just a question that applies to all of us presently in the protest space, but in South Africa at the moment, we have significant deadlock in sort of passing legislation. I mean, you would have seen engagements yesterday in Parliament that there's bills that have been lying on the president's desk for over 5 years. So he's just not moving stuff forward. He's also not sending them back or testing their constitutional validity. So we're stuck in a regulatory, I think Thomas used the right word, morass, in that we're not moving standards forward at the moment. And I think as people, we need to ask serious questions of both the executive and our lawmakers as to what is actually going on. So in terms of standards, I mean, the model bill that was introduced in 2011, we should be having a public conversation about that. Civil society activists should be in the portfolio committee, engaging with MPs on the side and asking why there's been no traction on this particular process. It's a very considered bill. The reforms that Thomas refers to in terms of the RJA and the SAPS Act, there needs to be clarity as to why those processes have not taken place. And I think that's the first point of call, to understand right now what the challenge is. Is it recalcitrance from the police? Is it a refusal from our president to engage in legislative processes and sign off on legislation? We need to understand why these deadlocks are occurring. And right now there's no clarity as to why our president is not moving forward on legislation. That's the first question to answer. And then outside of that, it's less about standard setting and it's more about engaging in policing culture. The police, as recently as 2021, are still referring to this nebulous right to order. It doesn't exist in our Bill of Rights, and there needs to be a thorough interrogation of how the police see our constitutional dispensation and how the people see that dispensation. So standard setting, we really have one more apex to reach. I think there's a cultural question in the South African police service as to how they see South Africans vindicating their right to protest and why they seek to suppress it.
I think that came out very strongly in the workshops that we've done with grassroots movements. I think one of the things that they spoke about was that, despite the limited protections that the RGA gives in National Instruction 4 as well, that most of the protests that they've encountered in black and brown communities is met with repressive policing, excessive use of force. They never ever, they come with a preconceived notion that this is going to be a violent community. And so therefore they are geared up, and they have an abundance of weapons. I mean, we've had a group basically saying that we essentially do not have the power. They coming with all of these dangerous weapons, albeit less lethal weapons, but they have nothing. They have stones. And one of the participants said maybe we should, burn down the police stations or throw back the tear gas canisters. That's all the weapons that they have. So there is this, cultural issue, or maybe it's really a remnants of our colonial past and our path and state policing that hasn't been redressed. We talked about the preamble of the Constitution seeking to redress past inequalities and discrimination and persecution. But we see that the culture, the police culture today is the same as when they were, or they still are, state apparatus, but essentially order and control was that was their mandate. And it seems that it hasn't changed post-apartheid. So, I mean, that is a larger issue that we need to address, And as, training with the police, I think there's been lots of human rights training with police. So how can we address that? How can we address the culture within the police force, the police service? I should actually say police force, because they're not really a service. How do we change that culture, the militarization of the police, the colonial nature of oppression within the police force?
I can add some reflections with this. I think it's interesting that this conversation is one that we're having all over the world, right? This is something that we're grappling in all the countries we worked with INCLO, and in the way that you're saying about this legacy of apartheid, we see the ongoing roots, sort of historical, structural roots of discriminatory and violent policing in a number of ways, right? In Chile, it has to do with the fact that the constitution and the framework of policing is a legacy of the military dictatorship, and that has not been modified. We can see that in the responses by police in the United States that very much has a legacy grounded on slavery, and that has not been addressed. So I think there's a long kind of a long history, timeline that we need to kind of look through. But I think, to me, it's even broader. I think in order to address an issue of culture of violence in police, I also think that us as a society, we have to kind of come back to why are we defending and what is the role of the right to protest, right? And the right to protest is made of a number of different rights: peaceful assembly, free expression, the right to political life. And when the right to protest is limited, all of these are at risk, and that is a warning sign to the health of a pluralist, democracy that is functioning. And so when we automatically equal protest to disorder and protesters to criminals, and that is not just police, right? Then we have a lot of work to be done. And this has been said already, but the role of police is not just, the right dealing with disorder, but it's to protect, to defend, and to facilitate the protest. And that one we always forget. So to me, that has to do with it. But I don't want to use say excuse, but the excuse, I'll still use it, of culture is one that we hear constantly. Last week, I was in Indonesia having a similar conversation, and they would say, police officers are young, they're tired, they're emotional. They are supposed to be trained, right? Like, this is not an equal component. They are supposed to be trained. And if that is something that fails, and this has been mentioned already, what kind of link can we do to authority, and who made that decision? There's a really positive decision that was made, yesterday, is ongoing today in Argentina, regarding protests that happened in 2001. Several people died due to the use of kips, the use of horses, and it is determined that there was a responsibility of authority, and they should be held accountable. And if there are consequences, then perhaps that is a first step to do that. I think there is an opportunity as well to work. I think sometimes these are we see them as niche or technical issues, but we need to work closer with media and journalists, especially independent ones, to be able to kind of give a broader, coverage to this, work on this kind of narrative change, because a lot of times we only pay attention to this when a tragedy has happened. So what can we do to have, attention paid and to try to prevent and mitigate that? And so it can be journalists, but also the amazing things about phones, about cameras, is that anyone can document. And there's some really amazing organizations that are doing trainings to help in that. And so that we have data and we have proof to help us when we're going into those accountability efforts. So, once again, I think we need to understand kind of the strengths in each one of our roles, and understanding that there is, I think Mike said before, there is a role for all of us to play as well.
So, I can give a quick practical one and then maybe a broader philosophical reflection. The Irish LaGuardia, the Irish Police Service, have a really interesting sort of ombuds mechanism where in all joint operation centers, so the operational command where the head honchos are sitting and they're managing the police response, they have human rights observers who are deployed into these centers by law. Not to interfere, but simply just to observe how decisions are being made and to note who's making those decisions, when, and what the context was. So if these matters do need to go to court, there's a counterbalance to which is often the prevailing police version. So that's a wonderful quick win, having these human rights monitors deployed into joint operations centers with, in the South African Police Service. I think philosophically, we need to grapple with why protests occur. So, I mean, when I was a young protest lawyer, I went to Brazil to a conference for INCLO. And, the Portuguese and Spanish translation of protest is often manifestation. So when people were speaking to me, they kept saying, there's all these manifestations. I was like, guys, what are you talking about, manifestations? Like, we're talking about protest, right? And they're like, no, these manifestations are happening. And that just got me reflecting, like, protest is a manifestation of something in our preamble not going well, right? So protest in between electoral cycles is one of the primary ways in which, people can show their discontent and their dissent. And I think if we look at our political discourse now, if we look at the way we engage with each other online, there seems to be a contemporary question with all of us being just very uncomfortable with dissent. We protect free expression as long as people say what we want them to say. You can protest as long as it doesn't become too uncomfortable for us. And I think we need to really grapple with dissent, as opposed to being a negative term, as a deeply positive one. The most effective teams and companies and organizations in the world have really strong cultures of dissent. It opens up accountability and it ensures transparency. And I think us grappling philosophically with why dissent is such an important component of a healthy democracy is something we need to engage with, not just in protest spaces, but in expression and other spaces as well.
Wonderfully put. It's 10 to 12, and I want to give everybody an opportunity to ask questions. I don't want to be the only one asking questions. So I want to open up the floor. And if you do have any questions online, you can put it in the chat, and Kemal will keep an eye on that. Any questions? Comments?
Mic check. Does this work?
Yep. Oh, you have a question.
Because I have a mic, can I steal the first question?
Okay. so after you, then you can give it, and then.
Okay, cool. So as Sheryl and Laura have mentioned already, we were doing these workshops all week. And I mean, Sheryl, you already kind of asked the question about the militarization of the police. But one of the reflections that one of the members who joined us in Cape Town had was the manufacture of these crowd control weapons and the use of them seem to prioritize pain over actually controlling and protecting the crowd. So I don't necessarily need an answer to that, but I thought it might just be a comment or a reflection that you guys wanted to maybe speak to. My actual question is to do with Section 9(2)(d) of the RGA. So again, I only know about that section because we were talking about it all week. But that section specifically speaks to when you can use near or less lethal force with firearms, so crowd control weapons. And it speaks to the risk when protesters or disruptors are potentially causing harm to kill or seriously injure someone. But it also speaks on when the same risk is presented to property. And so Michael, specifically, you've done a lot of litigation in this protest space. So is that something that you see as a potential or necessary challenge? You also mentioned we need to be cognizant of GNU and their, maybe more conservative approach to lawmaking. So would you say that litigation is probably a better option for that, or if that's even necessary to do? Should we take a round of questions?
Yeah. I understand maybe the academic approach or the need to understand the types of weapons that are being used, but I mean, it's diabolical. that these weapons are being created. And I mean that there's something that I haven't yet heard. It's creatively diabolical, right? Now, when that intersects with the type of people we find in the police force, I mean, it's very worrisome. I was at the airport yesterday at the lounge, and there's 3 senior KZN police officials, and overhearing their conversation, how they're talking about people, you know, it's these effing people. Now, we have those attitudes intersecting with these diabolical weapons. I mean, whether it's KIPs, whatever the case may be, I mean, my initial question was answered preemptively by Michael. It's, you know, is there a place for this at all during protests? And I mean, I accept that maybe that's not the question this is dealing with, but I think it's important for us to recognize that it's diabolical. Like it's deeply it's deeply evil to create these things that sole purpose is to inflict harm and pain. And I mean, I understand the rationale behind having a report to understand the medical harms, but if I throw a brick at you, it's gonna hurt, you know, and it's gonna kill you. You know, it's the type of language we're using. You know, these things are causing deaths, but you're going into a situation knowing that I have a potentially lethal weapon, and if I'm firing it at you, it's going to kill you. You know, then it's not. It's that negative language of, you know, these deaths were caused by, as opposed to police killed using with this, implementing these weapons. And I think it's important also for us to use that language because it sort of makes it real, you know. And just in closing, you know, I think the fact that these weapons are being so diabolically creative, you know, it shows that there's a discount on the value of life at some level of the chain, you know, because protesters, dissenters are not seen as people worthy of, you know, being able to exercise agency and so on. You know, they demoted to criminals, which has a stigma. But I mean, even in South Africa, criminals have full range of rights. You know, so again, I think the language is important, and it's deeply evil.
Thank you. Sorry, I have flu, so my question is twofold, or rather, I have 2 questions. So the first one is, so when protests happen, society is usually, you know, divided as to how the police is to react to the protest. So, for instance, these angry civilians, which obviously, as we said, they're validly angry, they have frustrations about what is supposed to happen. During these protests, infrastructure will be destroyed, roads will be destroyed, government facilities will be destroyed, and these are government facilities that innocent civilians who are not part of the protest will be affected by. So there's that question of a balance of now which rights are to be protected, because if government facilities are destroyed, these are clinics, these are schools, these are roads that will have to be used. Some people would say, yeah, but force needs to be used to, you know, to combat a prolonged protest from happening. So what are your thoughts on that? And the second question is, do we know of, you know, any system that the police has for when they arrive at a protest site, right? So when you were speaking about less harmful means, I kept thinking of, you know, if a child does something, you'll say, hey, stop. And they probably might not stop the first time you say that. And then the second time you'll say, stop or I'll smack you. So you warn them that there's actually going to be like repercussions to you not stopping. Then the third time you'll probably smack them for them to stop. So I'm just wondering, when the police arrive at a protest, do they actually have that warning mechanism, or, you know, is the issue that they actually just, on the first point of call, just use less lethal weapons? Yeah, thanks.
I'm wondering, Thomas, if you wanted to start, since we've... And then we can come to the room to answer.
I can try. I mean, just to pick up on a few of the themes, the question of pain versus actually disabling or confronting a threat. I think that does really get to. I suppose it partly gets to the cultural question that you were discussing earlier, in that some of these weapons are, and I suppose taser is the most obvious example of this, as a weapon that is designed not to inflict pain, but rather just to cause muscular kind of immobility. So in its designed conception, it is a weapon that can be deployed to confront a potentially lethal threat, a context in which a police officer may have been justified in using a firearm can instead use a taser to literally neutralize the threat. But what one sees in terms of the use of taser is that officers have worked out that once someone has been tasered, they can then reapply the taser to produce pain compliance, right? And so a weapon that wasn't designed, that kind of diabolical design, it wasn't designed to inflict pain. It was designed for a different purpose, but can be used to inflict pain. And that kind of cultural misappropriation of the design, and I think both of you spoke very eloquently about kind of the need for and some potential avenues for cultural change with respect to protest, but the need to understand and how to affect cultural change with respect to law enforcement officials more generally, both in the protest setting and outside it, is a continuing piece of work. And then the other question maybe that I could pick up on is that property. I mean, it's not with respect to less lethal weapons, but with respect to the use of lethal weapons to protect property is very clearly a violation of international law. And it's the part of the RGA that most explicitly conflicts, and Michael kind of cited those concluding observations of the Human Rights Committee and the CAT that will, I suspect, most directly have been thinking about that provision. But to link it with the other question about, well, what are the other equities at play in a protest setting? The property that might get damaged or destroyed is property that in some instances is providing a vital kind of service to the population, or indeed private property. One shouldn't necessarily create a hierarchy between different properties, but to say that you can't use lethal force merely to defend property is not to say that the police I'm trying to avoid using the word managing, but in facilitating an assembly should not be bearing in mind the need to protect property. It's just that they shouldn't be using lethal force to do it. So perhaps I'll stop there, and I hope I've left some other questions that you guys can pick up on.
So I'll start. These are all really, really good questions and kind of point to things that we're kind of constantly grappling with. And I absolutely share the frustration regarding sort of how awful sort of these tools are and how far that's gone. I mean, my entry to human rights was on work on right to protest and kind of almost celebrating the role of activists and so on, and then kind of having to take kind of another take on that and how that is undermined when we have these things. I think there's just so much we don't know regarding how these weapons are manufactured and tested. We have recommendations, for example, that governments should do their own testing, because we don't know, kind of how that has determined that this is not lethal or less lethal or things like that. So, and then there's been some interesting work, and this is kind of a little bit around this consensus that is building around a torture-free trade treaty. There's been some interest in looking at fairs. There are hundreds of these, where people are kind of showcasing the latest gadget. And I think what's going on would be interesting. There's, I think, a positive case in France where there was a fair, and the Omega Research Foundation and Amnesty France kind of called out the fact that there were some weapons that are considered tools of torture. And once again, this report from 2023 from Dr. Edwards, a UN Special Rapporteur on Torture, does kind of make this differentiation about things that are, inherently cruel, degrading, etc., and those that might have a role, a legitimate role. But those are uncomfortable, uncomfortable maybe statements for me as well. But we're trying to kind of be pragmatic and try to think of ways to once again minimize and mitigate. So there are kind of the short-term, medium, and long terms that we kind of have with them. But in the end, kind of for me, the goal is to stop businesses from profiting from people's suffering, and we are seeing that. Regarding the questions about society's divided, how do we respond when protests become violent or escalate? First of all, I think we don't question enough how often or not they become violent. I think there's an assumption that most of them, all of them, are violent, and actually that's not the case. An example to say that when Black Lives Matter protests were happening in the United States, if you looked at media, you'd imagine that they were all. And then there was research that was done that said, that 90% were peaceful. And then when they are not, who escalates? How often is it perhaps police that escalate when they should be trained in de-escalation? So I think that's another component. And then another thing that police should be doing that many times they don't do is to differentiate between individuals that might be violent and the rest of protesters. Because there are one or two individuals that become violent does not mean that others lose their right to peaceful assembly. And that is something that we don't see in practice. I am not a lawyer, and I am not from South Africa, so I can't respond too much to the specific of that. But I do think that there's been a conversation, and in other places there tends to be instructions. There are sort of phases that police should follow, and if I'm not mistaken, the use of crowd control weapon is 4th or 5th in the phases that police in South Africa should do. But I wouldn't be able to put all of my force there because I'm not the expert for that.
Thank you, Laura. I mean, I want to use the parenting analogy because it's a good one, right? So you've given us a case study of one parent who tells a child to stop doing something, doesn't engage in conversation, doesn't explain to the child why this is wrong, parent hasn't done their homework. They don't know why this manifestation is happening in this child. Immediately goes to step 2 and then step 3. That's the one parent. You now have another parent who's very thoughtful, who observes their child, sees why these tensions are arising, may intervene before the child even acts out to soothe the tension. But if not, tries to have a conversation with the child, speaks to the child, lets the child blow off steam in their room for a while maybe. And if not, at worst case, doesn't hit the child, but grounds them for 2 weeks, right? This is potentially another parent, right? Now, the South African Police Service is professionalized and paid by us, and they have a duty to be considered. So in National Instruction 4, and this answers, I think, both of your questions, there is a duty on operational commanders to manage situations, right? National Instruction 4 anticipates crowd management and facilitation way before protest occurs. So police are meant to go into communities to understand the fundamental root causes of tension. This is months before the actual protest occurs and start feeding that information back. They're there to start these subtle negotiations. And by the time a protest has started, there's already arguably some failings that have taken place, right? The MEC won't engage with people. Our recent mayor, when we're having water outages, refuses to speak to people. There's a whole bunch of social mechanisms that have failed before you get to a protest situation. And the commanding officer needs to be aware of these things. The commanding officer then needs to, as the protest starts, say, hey, someone go get me the MEC and let's start a negotiation. Let's de-escalate Let's engage in acts of precaution. And again, multiple steps need to flow. And it's only at the worst case that any form of force should be used. So it's very important to see force on a spectrum. What we see in South Africa is police arriving, jumping out of the car, and they just start shooting. And wildly. There's very little control there. This is a very badly managed response, right? So we need to ask questions of our operational commanders. Why are they not more savvy? Why are they not skilled in negotiation and engagement? And why do they always want to jump to force, right? So it's the way that we manage manifestations, protests. Police have a duty to start far before the fact, but they often don't. Another big challenge we have, and we saw in Marikana acutely, is the Amabaret, the tactical response team, was deployed in Marikana. They're sort of one level up from public order policing. They carry serious guns. And the TRT team that deployed was from KZN. So they ship a response team from KZN into the Northwest. And there's a cultural question. This team arrives on the morning. They don't know what's going on. They are then immediately deployed, and they get the job done in a very grotesque and unconstitutional fashion, right? But we need to grapple with the diversity we have in South Africa and the different community struggles, right? By the time a school or a hospital has been burnt, it's very easy just to blame the protesters, to blame a lack of education, whatever ridiculous narratives are used in the press. What we're not looking at is the 100 failings through the state that led to that intense frustration that ultimately enabled someone to burn a school, right? And that's what we need to start grappling with. That's where the police need to engage in sensitization programs and have a more human rights underpinned approach to public order policing in South Africa. And that's what we need to demand. That's the first thing. On property, I mean, INCLO historically has taken a very firm position on killing human beings over property, right? And I think it's very contextual. Now, it's permitted in international law, it's permitted in South African law as an act of self-defense or in defense of others. Now, shooting someone for kicking over a trash can, I mean, I studied at Wits and I represented a lot of the Forlists, the first generation of Forlists. Things changed after that, as we all know. But there, you know, down Yale Road in Wits, people would roll bins, right, as a form of protest, as a form of discontent. Should someone be shot for that? I would say, obviously, no, right? If the police have again failed to facilitate a protest situation, and one individual protester is just about to throw like a petrol bomb into a bus of people, I think it becomes more arguable, but it's situational and it's dependent. If the police are putting themselves, like they did at Marikana, in a position where they have to use force, it's unacceptable. What they did in Marikana is people were trying to walk home, and they put up a barricade to people's homes. If I couldn't get into my home, I would get scared, particularly in those contexts. The police created that situation and then try to justify the use of force that they created. If they had just let people walk home, we would have 36 South Africans who would still be alive today, right? So when looking at the use of force, particularly around property, there may be very isolated incidents where one person in the protest, individual right to protest, right? We all have it, where one individual may need to. And I mean, some of the guidance we got at Marikana was have snipers, right? Don't deploy them, but have them. If one individual is going to engage in an act of violence that is that severe, you may use that resource. But you don't end an entire protest because of that, obviously, depending on size. So I think you need to look at, there's far more nuance in what we require from our police. It's not just arrive in a bakkie and start shooting, right? It's to be ambassadors in our communities and to engage and to understand localized struggles so that they can negotiate and mediate solutions as opposed to violence. That's the first thing. The second thing you bring up is the tension of rights, which I find fascinating. So I'm in court at 1 o'clock in the morning. First interdict is being sought against the original Wits Forlists. I won't mention the judge, but I'm engaging on urgency with the judge, and the judge says, you know, what about everyone's like right to movement? You know, traffic's a bad thing. And I'm like, yeah, judge, what about the right to protest? The judge is like, fine. And the judge says, but what about this right to education? Now the protesters are stopping everyone from having education. What about that right? I'm like, yeah, Judge, but also what about the right to protest? And the point I make is that I think if you look at popular parlance, there's always a tension on rights, right? This is what Elon Musk doesn't understand about free expression, right? And we do in South Africa. You can express yourself in certain ways, but some forms of expression start to violate other people's dignity and equality, and that's where we start drawing the line, right? So there's a tension between free expression and dignity. We accept that, we grapple with it on a case-by-case basis. There is a tension between protest and other rights that may need to be vindicated. When we don't look after our medical professionals, we neglect them, and then they want to strike, and we say, you can't strike because of the right to healthcare. So our prevailing narrative is that protest is fine as long as there's never any other rights implication. We always diminish. We have diminished the right to protest, but it's on equal footing with all of our other 27 substantive rights. So it's that tension we need to grapple with. Why do we keep diminishing protest? Why is everything else more important? And it goes back to this discomfort we have with dissent, I think, ultimately. Thank you.
Yes.
Okay, I think I'm going to be the parent and say we'll have the last round of questions because we over time. Yeah, how many do we have? Two. Two? Mari? You okay? Okay.
Okay, good morning, panel. So my question is, we keep talking about police training and lack of training. I would like to know, do we have sight of the police's playbook? Do we know what it is based on? And if it is based on the prescripts of the Constitution and all the other things that it should be? That's number one. And then number two for me is, based on the discussions from yesterday, the workshops, I've now resorted to the South African Police Service with force. But that's also discriminatory, because when a protest in Eldorado Park is handled very differently to a protest in Bryanston, for instance. So for me, it is also, when we protest in Eldorado Park, the police come ready. So they come with their guns, and that already puts us not only off, but also confrontational. It makes us confrontational. So that's that one. So it's also based on the training. It's almost like when you go into Aldo's...
Do you mind holding your mic a little bit?
When you go into Aldo's, go with a different demeanor compared to Bryanston, right? And then number three was, so South Africa, I don't know, prescribes to all these various laws and international laws and agreements, etc., but they don't comply to it. So who holds them accountable? Because you said earlier that we should make noise with the UN. I might have gotten it incorrectly, but we should make noise and we should let our voices be heard. But where? And who holds South Africa accountable to actually do what they agreed to do? Thank you.
I'm just going to repeat, I think, those questions in case, I don't know if they were loud enough for folks joining remotely and so on, but there was a question regarding more information regarding the police training, what type of playbook they have. Is it based on sort of constitutional standards? There was another kind of point to be made regarding the discriminatory approach, so not every protest is policed in the same way. And then the other question of who holds accountable governments when they don't comply with international human rights standards, I think, is generally.
Okay. Hello. So I have a question, and so I've noticed recently that after 94, South Africa we were feeling great, so we ratified a whole bunch of international instruments. And now we're realizing that we can't fulfill these requirements, so now we want to pull out of them, right? And I've noticed that the state sort of has this idea that international laws are, if you can, try, just try. And they'll say that we'll bring up international law arguments, and they say, yeah, but that doesn't apply. It doesn't apply. We aren't bound by that. But they are. And there's this sort of pushback against international law. So how can we as citizens or civil society push the government through other means? Because they're not going to take it up legislatively. How do we push it in other means for them to actually commit and meaningfully commit to their international law obligations? Thanks.
Yeah, I can jump in. Thank you. They're both very good questions. And maybe let me start with the last questions about meaningful commitment to international law and standards and compelling compliance, right? I mean, does everyone remember the al-Bashir incident, right? There we had an international law obligation to arrest someone who had been indicted by the International Criminal Court. We got SALC, the Southern African Litigation Center, got a court order, but we all remember the picture of the plane just leaving Waterkloof, right? There we had an executive, a political body of state, who acted contrary to an order of court, right? It's very hard when that happens. That's where we need to exercise our right to vote. But international law was enforced through our courts. A year later, because now there's egg on our former administration's face, we just randomly try pull out of the International Criminal Court. So the LRC and others run to court, and we get that decision reviewed and set aside, and now we are still part of the International Criminal Court process. So South African courts are wonderful in compelling the state to do certain things. The problem we're currently having is the state is complying less and less. So there were wonderful stories early on in our constitution, right, where an order would be the right to life question. You know, there would be a fundamental constitutional court order that was given against the president of South Africa at that time, who was Mandela. Mandela would immediately go to the SABC and announce that he was going to comply with that order because he trusted our constitution. The same was true of Mbeki. We then have the third notable administration where we have a recalcitrant leader who refuses to comply with law. So when you suggest that South Africa sees international law as a nice to have, I would suggest under certain political administrations we've had post-democracy, the constitution was also nice to have and wasn't taken very seriously. And that is something that we need to compel compliance with, right? This comes from people, and again, it comes from the right to protest and how we exercise our right to vote. But we are lucky compared to other jurisdictions in that we still have a very receptive court system. And we have a court system which uses and relies heavily on international law. So you look at reports like Lethal in Disguise. Why is this useful? It's academic. What does it actually do? When we go to court on our next sort of protest case, everyone has the right to freedom of assembly. And when you interpret our Bill of Rights, when we figure out what freedom of assembly means to us, courts must consider international law and they can look at foreign law. So what do? We put Lethal in Disguise into the court back, you know? We put it before the judge. And we say, these are all the treaties that South Africa must comply with. And the judge will ultimately make a finding. So through our court system, through our third wing of state, the judiciary, international and foreign law is fundamentally powerful. And as long as our judiciary holds, as people, we've got something to push back on power. The conversation we need to start having is why, when we're getting court orders, our executive and legislative arms are no longer complying. And there, public interest lawyers are coming up with innovative ways, holding people in contempt of court. We've seen with former ministers, we no longer hold their seat in contempt of court, we hold them personally responsible and start going after their bank accounts. When you go after people's money, they generally stop doing what they're doing, right? And these are things we're trying to test at the moment. I think that's the first question. On discrimination, I mean, this is the historic struggle, right? The rich versus the poor, and where a police service acting on a state positions itself. There is no doubt that there are differentiated and discriminatory policing responses. I mean, you see it in South Africa, in El Dorado, you see it in Chicago, where you still have a police service that is accused of racism on a daily basis. And they haven't been able to shake their sort of 1920s approach to policing 100 years later, right? It's something we need to engage with. And again, this comes from evidence collection, right? We need to start putting this before courts. The problem with protests, they're very ad hoc, and they come and go quite quickly. They're not often recorded, right? And it's often a police version. We say this, you say this. We need to start getting things on video effectively so that we can go before judges and say, look, here's the Bryanston protest. Look how everyone's left alone. And here's the Eldos protest, where the police immediately jump out of the bakkie and just start shooting. So it's all about gathering information. And that's the challenge I've had as a sort of a protest lawyer. Is people come to me with horrific stories. But it's the classic case of what can I prove in court? And often that documentary evidence is not there, right? So I wouldn't discount international law. It's a fundamental thing. I think at a very macro level, we need to accept sort of the shifts between good and evil, right? And I think the international human rights movement, which started with the UN, grew through the US civil rights movement, grew into our wonderful constitutional dispensation. There's a lot of pushback on the international system at the moment. You're seeing people like Trump and others really trying to do violence to multilateralism. We as a country have expressed our commitment to it. It's in our preamble and it's in multiple constitutional provisions. And we actually need to keep and fight and remind our state of these commitments that have been made. I don't see a better system than a multilateral system, but autocrats and people who don't want to be overseen love that system, right? And we as activists in this room need to keep fighting for that position. Even though it may not currently be in vogue, there are very good reasons for the start of the international human rights movement. There's a very good theoretical rationale for the United Nations. It may not be as functional as it should be, but there's simply no better system, and our job is to slightly iterate and make it better at the top level, and then to gather evidence in the grassroots so that we can use our courts who ultimately help us vindicate those rights.
Yeah, I don't think I have a lot to add what Mike has said, especially at the end, but I think to me it reinforces the kind of differentiated roles that we have. And so the international system has its place, it's grown and advanced so much thanks to kind of the different inputs to it. I think it creates those minimum standards that then we kind of have to work. But then, you know, we can't just leave it there, right? And that's where kind of from CSOs to lawyers to activists, we all have kind of a complementary sort of role there. And, you know, what I've been learning sort of in this week and so on is that there is, you know, a lot of positive in South Africa and kind of its history to it. So to kind of, you know, continue in that legacy seems to be important. I think almost for any of these questions, but definitely the one on the discriminatory approach, I'm just kind of constantly reminded of how universal this experience is. That's both a bad thing, clearly, but also I think that we can learn a lot from each other. In all of the countries that INCLO is part of, we see this. It can be on the basis of race. We see a different approach to the policing of indigenous persons. I think especially in places that are rural and might be outside of our attention. There's a difference between a protest perhaps in a city and what's happening outside. I think this is going to be a growing issue as environmental rights continue to be fought for, as the tensions with extractive industries become more at the forefront. So I think, once again, to that, and repeating what Mike had said, I mean, documentation and kind of monitoring is kind of key. And that is not something that just springs in that moment. That is a training, that is a structure that needs to be put in place. And there is a wealth of information. There are some amazing organizations do it that, just to name one, Witness is an organization with kind of regional work that trains activists and protesters to do that. And with that, there's so much more that can be done than taking it to court. But that needs to be kind of something that we enforce and we learn in advance.
Thank you. Thomas, do you want to say any last words before we close?
Well, maybe just briefly to comment on those kind of two general topics: the value of international standards and international law. In the first place, back to my kind of original presentation, I think there's a very international piece of this puzzle in terms of the international trade, and that is a space that international law is well equipped to address if we give it the power to do so. And I think that could lead to quite meaningful change in the international, but also at more national level. I think the dissonance between international standards and national legislation that we've all, I think, highlighted in the South African context is not unique to South Africa. Another of Christoph's great projects was a review of national legislation on the use of force around the world, and there is a shocking proportion of national legislation on the use of force by the police that does not conform with international standards, and in all of those places there is the same inertia to legislative processes to update that legislation. But I think we have seen improvement through the sensitization of the police themselves of the international standards, because police work with law on a day-to-day basis. They know how slow a process it is to change law, and they can be aware of the fact that, well, while the national law may say this, actually, things have moved on since the time that law was adopted. International standards, international, sometimes good practice, things that are actually international obligations can be framed as good practice, and police can be kind of encouraged towards good practice as a means of for example, around the use of lethal force around property, the training police officers on the international standard rather than the national provision, at least anecdotally, from South African police, is the way they train that these days. And so the international law can kind of overleap national inertia. But I mean, I think, as we said kind of right at the outset, the persistent campaigns to try to get movement in that legislative, in that political space is very important. And just on the discrimination point, yes, I think that's true of disparate policing responses to political protest in different contexts within a country. One sees that as both Laura and Michael said, in different parts of the world as well. I think it's also worth bearing in mind, and this is a kind of device that I often use when speaking to police officers. The legitimate law enforcement interest in facilitating working around protest is the tens of thousands of people convening in the same place at the same time. That does bring with it safety risks, and it is part of the role of the police to mitigate and safeguard against those risks. But so contrasting a political protest, not just with another political protest in a different part of the country, but also with other occasions when tens of thousands of people come together. And I often will talk about, a soccer match in South Africa will have a similar, or oftentimes a lot larger number of people coming to a soccer match than to a political protest. And the ways in which the state, and this goes back to Michael's point about, the perception of dissent and this particular concern that we have with political protest. But in terms of what is supposed to be the police's concern, namely that kind of safety risk emerging from large groups of people coming together, we really ought to be highlighting the distinction between the way in which they maybe respond to tens and tens of thousands of people coming to downtown Joburg to a political protest. And so there are differences, obviously, but it's another reference point that if you can record, as Michael was saying, the differences in the way in which the police respond to what is on its face the same kind of risk profile, you can highlight the problems with certain of the responses.
Thank you, Thomas. And I think on that note, we'll close this section, and I'm going to hand over to Kemal, who's just going to make some concluding remarks. Thank you.
You can take this one. Okay, that's working. I'm going to stand here next to Lewis Hamilton. So I just wanted to just say thank you to everyone that came here in person and everyone online. It was great to have you here and participate in the conversation. I just wanted to also, reflect on the whole week that we've had, because we've been running these workshops, as been mentioned, and it was an incredible, learning experience for us at the LRC and INCLO. Not only about the dangers of these crowd control weapons, but the impact that it's having on communities. And I think probably that's the most important part of what we've done this week, is hearing from people that these weapons particularly and specifically impact. And I think it was amazing that we got everyone's contact details, and we've made strong relationships with them so that we can further support them in the future, but also that they can now feel empowered by this incredible report put together by Shral, Laura, Rohini, and everyone else. In particular, I wanted to, because she's not here, say thank you to Rohini. Her medical perspective that she gave us during the workshops was grueling and hard to see, but really important that it was there. I just want to say thank you to Thomas online for joining us, and Michael as well in person. It was incredible to have your expert's opinion here. Cheryl for leading us, and Charlene for organizing everything. And then a special thank you to Laura, who came all the way here for us and brought her expertise and facilitated all the workshops, and really all the hard work was done by her. And so, yeah, everyone, thank you for coming. We have some snacks outside, some lunch. Yeah, concluded.